have seen me give these presentations before, and you'll see a lot of the same things because a lot of these principles are somewhat immutable and they don't really change very much. Policy changes in terms of taxation and things like that. And I'll speak briefly about estate and gift taxes. But what I've found, one of the new challenges of serving in a dual role of cooperative extension and university faculty is I start talking to both audiences about the same things. And so every time I come back in and do an extension presentation, I've got to start pulling some of the basic stuff out. But I realize that what I'm trying to do, even in an adult education setting, is really just lay down some basic terminology and concepts that you walk away with. Because estate planning and wealth transfer, by and large, I mean, there's a lot of work you do yourself. I mean, a lot of the we can even call it physical labor of doing various things involved in estate planning. But just as a general caveat, it is best done under the advice of counsel in terms of getting the language right and getting the right documents in place that will pass muster when the rubber hits the road. And that's sort of what I have found in my life prior to extension. I have a bio slide here. I was in private practice and worked all around North Carolina, mostly with farms, almost always with land, and wrote, I don't know how many wills and trusts and LLC operating agreements and things like that. And my clients were always trusting me to get the right language and address the situation, because part of my role, and it should be part of a lawyer's role, but I think, a lot of the decisions in wealth transfer and estate planning, they're all your decisions, and how you come to those decisions and articulate those decisions to who you're working with is critically important. And over time, I found that plain language, write down what the client's saying and not what, you think the bar examiners would say, and try to get it right, but keep in mind the various contingencies. But my point being is that you can draft these documents, but eventually they get tested. Eventually the rubber hits the road. Eventually somebody dies. Eventually, property is distributed, something happens, and the sufficiency of these instruments is tested. So, and I'm in a way going through that now in my career. I'm full-time at NC State, but I've got former clients that stay in touch with me and ask questions about things that we've done, 5, 6, 7, 8, 10 years ago. So, but my background briefly, like I said, I was in private practice. I'm barred up in Virginia and here in North Carolina. I came into this career through the nonprofit sector, focusing on farmland and the issues surrounding keeping as much of our, 6 inches of the surface of the earth intact and available for farming as possible. And with a specific focus on decisions that families make to transfer this land, transfer the operations, transfer machinery, make it possible for the next person coming along, not necessarily to step into the shoes of the parent or the grandparent, but to have a fighting chance at carrying forward their own business, the thing that they're going to do in their life, because it will change, it will have changed, and there's a lot of challenges ahead for that person in terms of acquiring the resources that have existed in that family, because they may not necessarily be on their way to that farmer by inheritance. Most families I've worked with stick to a goal of equality among their children, which, as you can imagine, makes it difficult when you have one child that's in the family and is depending on those resources for income, for a career, and others aren't. And so that was always one of the biggest and I would say, fun challenges of being a lawyer working in this stuff, is really going through the assets and saying, well, here's what this farm's going to need, and the forested tract over here, we can send that to the daughter that lives in New York can inherit that. But like I said, I was in private practice, and then I got the call from NC State a couple of years ago to come over and fill a position that had been there in ag and resource economics. And so this has been my greatest career challenge. I'm really, really, really enjoying it. So another little bit of shameless self-promotion, just to let y'all know, and I put the link up in the chat box. This is my extension website portal that I put up. Cases come out, I write about them. Things happen, developments, federal policy, state policy, but I'm also there populating the website with resources, with templates for various documents, narratives on various things like wills and trusts and LLC, limited liability companies, leases, all manner of topics, really under the concept. It's real small print there, but of what I call farm transfer and succession, which is our topic for today. And there's also, I'll show you real quick. There is a resource in here that just want to bring your attention to, and that is, it didn't let me do it. Sorry. Tried to bring another a screen in, and it didn't come in, but it's called Planning the Future of Your Farm. And it's a workbook that's been developed a while back, but it's there as a PDF on the website. You can download it, and it's got a lot of material in there to help with the decisions that you're going through in terms of what am I going to do with my resources, my wealth and my land and my money and all of that when I no longer have it. And again, I encourage y'all to, this is just me, sort of how I go about presenting these slides, but I'm really curious to hear from y'all, what you have on your minds. And so please send some questions into the chat box. I have a different presentation up here on a different screen, which has probably much more information, but I'll stick to the basics in this one. I say this lawyer, me, because, this is just how I tended to approach this over the years with clients. But my first goal always was, and I say, well, mine, and I would, encourage this to be the client's goal, is that if possible, really go through the thought process of looking at all of your wealth and your assets and the different types of assets, and figuring out how those are going to be distributed. But when it comes to land, try as best you can. If you own, several tracts, or if you own land and other resources, try not to give, a single tract of land to multiple heirs. And that's critical in farming when one of those would-be heirs is using that land as a necessary resource. Because in some respects, it complicates, unless you do some other things like lock in their tenancy to it ahead of time for a long-term time, they will be in the position of having to buy out their siblings. And that's okay if you take some extra steps, which I'll point out, but I'd never like to see the person who wants to use that land as their home base for a farm that they're developing or a farm that's already developed, to have to negotiate with siblings on what their price is, because that price is not set. It's something, it could become a matter of dissension in the family. And I've always said that land is a fertile field upon which to play out sibling rivalries. So it's best to keep them off, keep your kids off the same piece of ground as owners. And I always say the estate tax, I say it's not the issue, and I'm saying at the moment. We are an election year. We don't know, how things are going to work out, but the estate tax exemptions right now, North Carolina has abolished theirs. So there is no tax on the transfer of wealth at death at the state level. There still is a federal estate tax, but the exemption of the amount of wealth that you have to have for any of it to be taxed, you're exempted. I think currently it's $11.4 million per person. Married couples can combine that for effectively $24 million exemption. So your estate does not pay a tax on your wealth transfer at death until you reach the first dollar after 11.4000. So It's only at that point is a tax paid. And I'll explain how giving away property during life affects that. Um, but again, that could change. The exemption could go way back down depending on how things shake out in November and beyond. So, but I say it's not the issue because I've a lot of estate planning, uh, especially in farming, that I would see that was done, just had this on the brain. It's like all that as if the only issue was the estate tax, worrying about not creating co-tenancies and heirs on land, not really dividing up your farm assets, things like that to the farm heir, seemed to be of secondary importance. And it was always about the estate tax. I don't want the government to take away my farm. Turns out it was somewhat of a rarity, did happen, but not as, my opinion, not as common as certain advocates of its abolition would have us believe. Always, always, always be careful about present use value property tax when you're disposing of land, particularly subdividing it. As you know, and we're in a farming course here, so we're most of the land at issue, I would say, or most of the land owned by folks in the call, is enrolled in the present use value program, and so you have to be very, very careful not to do anything to that land, like subdivide it, to parcel out a home site for a child, or to split a tract in two and get one to one and one to the other. To be careful not to disqualify the property and render it subdivide it into tract sizes that don't otherwise qualify. And the other caution that I put out there, and I faced this several times when I was in practice. For example, I would have a client who had, let's say it's a 25-acre tract of pretty much pasture, maybe a few trees, but pretty much pasture, and wanted to divide it right down the middle between one daughter and another daughter. And it turned out that that I happened to know this land, and I was pretty sure that it was not earning $1,000 gross in income. That it was just being used to graze some private horses, and my point is that what was going to happen is when the client hired the surveyor to come out and subdivide it, file the plats, parcel out the deeds to each daughter, the tax office is going to catch wind of it, and every time land goes through a transfer, the tax office examines it. And even though you may have been paying present use value for years and years and years, and the tax office never got around to auditing, at that point they will examine it. And if they look at the records and you can't produce records of earning that income, they're going to kick it out. And this is becoming more common in exurban counties. I practiced statewide, but my office was in Hillsborough. And as you can imagine, Orange County, they became real sticklers for this. Wake County is sticklers for this. Pretty sure Durham, I know Alamance is, they hired one of the first staff members in their tax department to ensure that land was properly enrolled. And at that point, they started kicking it out. And I guess the last thing, and I'll move on to some more technical stuff, but this is just more of a personal observation. Try as best as you can when you're doing your estate planning, and particularly if you're protecting a farm legacy, think about the obligations that you leave behind, and make sure that those obligations are fully shared by the people that you are passing them to, because it can be very, it can be a driving, it often is a driving force in farm estate planning, to keep the land intact, and forest planning too, because you have a lot of acreage and you're managing that pine, but to keep the tracts intact and not have them filtered away through dispute and whatnot. But often the generation planning, they have a very strong motivation to preserve their legacy. And it's a legacy that they themselves preserved from a parent sometimes, or even a grandparent. And so that driving force is very strong in the person who's planning their estate. But I always say, just be careful not to make an assumption that the folks coming behind you, your family, is fully on board and shares that obligation, because once um, the way I see it is that obligations also themselves can tear families apart, because uh, you can have a family. It's like you have the family member. One is committed to preserving the legacy, but it requires the cooperation of the others. The others may not be on board with it and may feel stressed that they're not doing enough, but they don't have the motivation to do it. And the person who's doing it is stressed and mad at the others because they don't feel like they're pulling their weight. So my point is, think carefully through statements like, you must keep this farm in the family, you must do this, you must do that. So that's not really a legal thing. That's just more of an emotional plea to not expect people to carry on your wishes indefinitely after you're gone. First things first, and this is very general, but another common planning concern is, well, I don't want the nursing home to get my farm. Well, the nursing home's not going to get it, because you won't be going to a care facility unless you can pay for it. And the only way you can pay for it is by having the cash to pay for it, or being so resource poor that you actually qualify for Medicaid and the state pays for it. And so qualifying for Medicaid, again, you must have almost nothing to your name. A rinky-dink car and your home, but not a lot of assets, and certainly not a lot of farming assets. And so while you can dispose of assets ahead of time, if this is going to be your plan, just know that you have to do it 5 years in advance. I'm pretty sure it's still 5 years. 5 years in advance of filing that application for Medicaid, because if you've had the resources in that 5-year period prior, it does disqualify you for a certain formula of months going forward, and you can't get there. So, this is just somewhat of an Andrew statement, but if that's your plan, to have the taxpayer pay for elder care, you've got to support that policy in the first place, because the policy wins are against Social Security, what we call the entitlements. I hate that word because they are privileges, but the policy wins. At least, we can't dance around the fact that our country is very, very divided on these issues right now. That a certain one side of the country's brain wants to get rid of all this government assistance, and so if your plan is to go on government assistance, you have to support the government assistance. And I'm not advocating for that, but that's the central policy there behind that fear of losing your assets because of elder care costs. It's not a cake and eat it too thing. So anyways, but something I do to start us off, I guess, or get us to the technical stuff. So I've become fond of quoting Sir William Blackstone, because as I write about property disposition and wills and trusts and things like that, this question always bubbles up. Well, where did this come from? And this is really me talking to my ARE 306 students. But this question has been debated since classical times. Why the occupier of a particular field or of a jewel, when lying on his deathbed and no longer able to maintain possession, should be entitled to tell the rest of the world which of them should enjoy it after him. And that's a legitimate question that's been debated for forever. And the overall philosophical consensus is that we needed to have an orderly society. We can't have everybody fighting over objects that are left behind by people. So we've developed this pretty concrete system of how assets are transferred, or how they descend to heirs at death. A lot of it has to do with how your property's titled, of your planning. I call this review because I always assume most folks understand this. Your land that you hold in joint tenancy, and most joint tenancy titling is between spouses, and we call that tenancy by the entireties. And so essentially the law assumes that when you acquire property while you're married, that it's joint property, that both you and your spouse are going on the deed, And when one of you dies, that land is automatically 100% owned by the spouse survivor. It's not a that interest, your interest that you own, your 50% undivided interest, does not go to your heirs, and your wife is not your heir in this instance, or your spouse rather. It's just your joint tenant. The only thing that severs that is a divorce, or selling the property to somebody else. And so, one point that I always make out to folks is that when one side of the marital relationship inherits land from a parent or from somebody else, it doesn't make it joint property. It's still the sole property of the person who inherited it. And so it's often the case that, and sometimes this is parents' fears in estate planning, that their child is going to make it joint property to a spouse, and that's out from outside the family. And so, but as is often the case, this will often happen, that the person who's inherited the land is going to execute a deed and from themselves to themselves and their spouse, and make it jointly owned property. And it means that the surviving spouse gets to decide what happens to the land. It's not necessarily the person who inherited its decision, because they may die first. But do know that spouses do have rights, what we call inchoate rights, that don't exist yet, but may exist by law in the future, to property that's been inherited by the other spouse. And this can happen at death, through filing an elective share, or filing for a life estate in land. That's also in the statutes, or at divorce. A judge basically saying, yes, this land that you inherited, we need to split that up because you need the equities of the divorce require an equitable distribution. So it's possible. Tenancy in common differs, of course, because each tenant can freely alienate their interest. They can sell their interest, or they can die, and their interest is then inherited. It doesn't become owned by the other co-tenants. And this is, I would argue, one of the most common ways that land, particularly farmland and forest land, is owned in North Carolina, because just the way people write wills, they say, if I die, it goes to my spouse. If my spouse predeceases me, it goes to my children, share and share alike. And those children are now co-tenants. And so that situation up here at the very, very top that I was talking about, well, right there, is essentially what happens. And then those tenants, those co-tenants, are having to treat with one another about how they're going to sort those out. And I think 99% of the time, families work this out. You know, the person who wants the land finds the money, can go gets it worked out with a lender and is able to buy out, or there's a timber sale and they give up their portion of the timber in order to buy out the other interests. And so there's any number of ways it can happen. And then finally, life tenancies. As you know, a life tenancy is what we call a consecutive interest, where a person takes a deed to property while they're alive and deeds it to somebody else, but retains the right to live there for their lifetime. As such, they have a responsibility to pay the property taxes and basically to keep up the property, not let it go to seed. And so, in a sense, the what we call the people who are going to own the land after the life tenant dies, they have certain rights that they can protect if they see that the land is not being preserved. I've never been a fan of creating life tenancies in farmland or forest land, particularly because it causes dispute between parent and child. I've been in several cases where, and on both sides of this equation, where the parent wants to cut timber for some income. I mean, there's mature timber on the property. There's a lot of mature timber, and the parent wants to cut timber. Well, the remainder person, who the son or the daughter who's been transferred, has received this interest in the property, or I'll say rather, maybe their spouse, says, no, those are going to be our trees. That's our money. He or she can't have it. And so it creates a real challenge. It happens that as it happens, there is a partition statute that allows a life tenant to go to court and partition off the timber and get it sold. But it's a process. It's not something that's just like that. I don't have as much of a problem doing life tenancies in residencies. Another reason I don't particularly favor life tenancies is that that let's say mom is living there for the remainder of her days, but the son or daughter is farming all the land. Well, as you know, that land is going to be probably needed for collateral at some point for operating loan money, and as such, mom's got to sign that promissory note too. So dad or mom stays involved in that operational equation. And I'll talk about business entities in a while. I feel like I'm not moving forward fast enough. But when you find land in tenancy in common, or excuse me, if you can't avoid creating co-tenancies, creating share and share alike in your heirs, there are ways for them to deal with it. There's ways for you to deal with it ahead of time. Maybe using language in a trust or a lease or something like that creates options to purchase. There's also this thing that I had started to use late in practice, and I have a template for it that I'm preparing for extension called a tenancy in common agreement. And it's short of putting your land into a limited liability company, but it's just a contract between the co-tenants, the siblings that own this land, that when one of them wants to sell, they have to offer it to the others. It talks about management, payment of taxes. How are we going to agree? Because one of the challenges in co-tenancy is that one person ends up paying the taxes, but that doesn't create any additional ownership right. It doesn't all you're doing there is surviving. It doesn't, just because you've been paying all the taxes, it doesn't mean your 1/3 interest is growing in the property. It's just you're paying the taxes. So, but a tenancy in common agreement can, get everybody on board in terms of how that land's going to be managed, can have options to purchase, buy, sell language, how it's going to be appraised if somebody wants to sell their interest, and all of that. So, again, I did a few of them, but I can't call myself an expert, but I'm preparing a template with annotation for an extension project that's funded by North Carolina Tobacco Trust Fund. And these are just some other examples of language. I know that's a lot of words. I'm not forcing you to read all that, but these are just examples of how these things might be phrased. And I know this presentation will be available on my site. Matt and Martha might have a way to send it out too. But again, this is when I talk about giving heirs a fighting chance to manage the land, to own and manage the land. This is what I'm talking about. They may not get the interest outright, but they may get the interest. Everybody might get the interest with a string attached to it. And the string is that if you're going to sell it or you want to get rid of it, there's a structure by which you treat with your co-tenants, your siblings, and you have basically a structured sale and purchase, and not leave it open to whim or argument or whatnot. Now, people can argue about this, but at least this is enforceable in court. So, and when something's enforceable in court or it has that air about it, it does bring people to agreement a little bit faster. So I'm going to talk about basically, I got a lot to cover. I'll make a comment about powers of attorney. This is probably not something that is new to y'all, but I want to raise something in our current pandemic. When back in March, April, when things, really looked bleak, we didn't know what was going on. I started to think about my living wills that I had written up for clients that have language in there that says, if the only thing that's keeping me alive is ventilation, or this machine, that if I'm not on it, then I have no hope of surviving, then I require that you remove that and let me go. And I started to fret about that a little bit, because like when in this coronavirus with the COVID-19 disease that attaches to it, or any other type of virus, a ventilator, it can bring you through. It does, it is necessary treatment. And so I'm sure it's unfounded, but I think if I was writing a living will right now, I would probably put specific language in there dealing with care during a critical illness during a pandemic. So I'm going to go through quickly. I'm going to focus mostly on gifting property and the decisions you make about disposing of property at your death. Sale, that's probably for another time, but that's mostly a discussion about capital gains tax. And at the end, I'll come back to it if you want me to. But so I generally look at transferring property at death as, or disposing of property. If there's three ways to do it: you can sell it, you can give it away, or you can die with it. I look at property transfer as either having strings attached or no strings attached. No strings attached, you give your property away. You just gift it. You execute a deed for land. You execute a deed, and that's that. Or if it's personal property like farm equipment or livestock or whatever, just draw up a bill of sale. You call it a bill of sale, or a bill of gift or something, and just say that it's unequivocally that it is a gift. And at that point, you've relinquished all dominion over it. So the law considers that to not be your property anymore. You have no further rights in it. Unless you reserve the rights, unless you reserve the right to farm rent or to timber, you don't have the right to those income sources anymore. Of course, selling property, same thing. You're selling it. You can sell property, and if the buyer allows this, reserve something like timber. Maybe even reserve a farm lease if you're still farming. Those are certainly possible. And then to just distribute by will. And I look at distributing property by will as pretty much a no strings attached affair, because you're distributing it. You're saying here's the property that's going to be distributed. If it's land, it's done automatically, and once you die and your will distributes your property, or you die without a will and it's going to be distributed by intestacy, there's never a way in law to go back to the time before you're dead and rearrange how that's going to be done. It's pretty much set in law that at that moment how things are going to be divided. Then, on the other hand, there's strings attached. You can transfer property to a trust either while you're alive or during death, and have the trust, under the fiduciary responsibility of the trustee, follow your wishes and make certain decisions depending on how much discretion you give that trustee to dispose of your property. And when I was in active practice of farm estate planning, I relied heavily on revocable trusts in transferring assets. Reason being is, to me, it sort of creates a timeout. When the principal dies, when the person who created the trust, in a will situation, the property interests transfer like that. They happen at the moment of the last breath. Title transfers, and it doesn't come back. It is now done. But with a trust, when the principal, the person who created the trust, who you would consider to be the owner of the land, when they die, either they've placed the land in the trust while they're alive, or their will places all of their assets into the trust when they die, and it falls under the technical ownership of the trustee, and it's somewhat of a timeout. And the language of the trust can then guide the trustee to assess the situation around, and you can put language in there to say that if this child has a gambling problem, or if they're in bankruptcy, or if they're going through a divorce, they have a disability, something has happened, you want to empower the trustee to be able to make wise decisions about not transferring property yet. It will be transferred someday, but not just yet. About holding property on behalf of a beneficiary who your heir would be, but not let them have that property right away, because doing so, a spouse could, a divorced spouse could get it. The bankruptcy court could get it. It could disqualify them for disability payments, things like that. So It's very, very, very useful and very flexible. And likewise, strings attached. You can also inherit, so to speak, interests that are tied up in a business entity. In families, it's very common for families to use limited liability companies to own their land and then transfer the interests in that limited liability company to people who are, according to the terms of the entity, are allowed to own interest in the entity. It's a very controlled environment for transferring interest in what you would consider land. But I learned this from one of the many folks that have mentored me over the years, Dr. Leon Geyer at Virginia Tech. He was giving a presentation, I think in Blackstone, Virginia, a long, long time ago, relatively. And he put up statements: you can't paper over humans. You can have all of these documents, and the care with which the documents are worded are meant for their enforceability in court, but they don't automatically do the work. They don't automatically make the humans do the right thing or not try to cheat or be lazy and not file things and things like that. So whenever you have a trust or you have a business entity, know that it's a living, breathing thing that you have to keep alive. And there's a number of partnerships, limited partnerships, corporations, things like that, that you as heirs of land or heirs of these interests might inherit. Just know that when you do, there's a document somewhere that dictates, what your interest is and how it can be disposed of. And I find that a lot of these old agreements, some drafted back in the 80s and 90s and whatnot, they just don't have good buy-sell language in there to guide the owners through how they dispose of their interests among each other. And it just, it creates kind of an area of confusion within families. Moving along past this, just mention estate taxes briefly. Just remember that that we have a very, very high, this is my opinion, a federal estate tax exemption. Most folks I've worked with fall under that. And that's what applies when you die. That figure is also tied to what's known as the gift tax. And so people do give away property over their lifetime, and you are able to give up, or allowed under Internal Revenue Code and the regulations, to gift up to $11.4 million during your lifetime. If you do that, because that's the same number as your death time tax exemption, you have a zero exemption at your death if you were to gift all $11.4 million away. Now, the law allows us to give away an unlimited amount of $15,000 gifts inside of a calendar year, per donee. And so if the amount of the gifts in total, and that means throughout the year, it doesn't mean just one check for $14,999. It means a farm implement or a car or whatnot. And if you exceed that $15,000, you're required to file a gift tax return next April to let the government know, let the IRS know that you've made a gift in this calendar year in excess of $15,000. Why do you do that? Because it alerts the government that you've dipped into your lifetime exemption and, by correlation, your death time exemption. So always looking for new ways to explain that, but that's the state of estate and gift tax as of September 24th, 2020. Will it change in 2021 or beyond? We'll see. We don't know. And just to let y'all know, my son's making an appearance. So what I will say about gifting, and whenever I've managed a gifting project with a farm family, one of the downsides to gifting is that the donee receives your basis. Your basis, excuse me, is what is the value of the property at the time you acquired it, either what it was valued at the time of when you inherited it, or the amount that you paid for it when you bought it. And so If you gift your property, the person you give it to is going to have your basis in the property. And so if they go to sell it, and we assume that real property land has appreciated, they will be faced with a higher capital gain tax at that time, because the fair market value that they sell it for is going to be subtracted by your basis, but their basis, which was your basis, is very low. If you hold on to the property while you're until you die, you get what's known as a step up in basis. And so at that time, the property, as it goes to the heirs, will be valued as of the date of death. So it'll be, theoretically higher, usually much higher than the basis was that you had during your lifetime, the acquisition value. Gone through this. So I'll talk about wills and trusts a little bit. I just know that when you die with a valid will, you're known as a testator. You've died testate. You've taken the time to go ahead and share your thoughts on paper as to how you want this property divided. If you don't do that, or if you do it in a manner where the will isn't accepted in probate, or it gets struck down through a challenge, then your property is distributed according to the North Carolina Intestate Succession Act. And that does so in a manner of, it's codified in law, and addresses distribution to the spouse initially. The spouse is entitled to a certain amount of property, certain amount of personal property up to a certain amount, and then a certain amount of the land. And then after that share is satisfied, then the law addresses how the property is distributed among children and children of predeceased children. And if that doesn't happen, then the law also allows for property interests to go laterally and upward to siblings and parents if there are no children or grandchildren to take that property. So a lot of land is owned owned because of intestacy, where you'll have multiple heirs on that property, and often they will have differing interests according to their generation. You might have 3 to 4 generations sometimes owning a piece of land, and it becomes somewhat difficult to sort out. I'm going to blow through this. I'm doing a program here pretty soon. Well, I'll introduce these concepts to you so you can think them through. But I'm doing a lawyer CLE program on the difference between per stirpes distribution and per capita distribution. And for your edification here, when you see the terms and you have those of you who have a will, these terms are in your will likely. Depends on who drafted it. And sometimes people write their own wills, and that's fine. Per stirpes means essentially, when you write that if a child predeceases you, which is certainly possible, that their interest that would have gone to them is preserved for their lineal descendants. So their lineal descendants will then share will share the share that they had, but they died, so they don't have it. If you write per capita, that just means that if one of your children predeceases, then their share is extinguished, and what's there is divided among the living. And that does happen. And sometimes it does happen by a misuse of language, which is what I'm going to explore in this CLE to the lawyer people. But for example, per stirpes, I've said, I've devised and bequeath all of my assets to my children per stirpes. What that means is, well, one of my children predeceased me. I'm taking the spouse out of this equation, but one of my children predeceased me. And so I had 3 children. That's a biological certainty. If I adopted a 4th child, I had 4 children. So legally adopted children are considered lineal descendants. Then my assets would be divided up into thirds, and that deceased, because the deceased child had 2 children, that third is going to be divided up into 1/6 each. And I'll make a note here. Well, let me do per capita, and per capita is, as you expect, the different result. If I said per capita, that means if one of my children predeceased, and that's too bad for their children. They won't inherit a share. It's funny, as a lawyer going to law school, and most lawyers see this language and like, I know what that means. It means the share's being preserved. It's a little bit more complicated than I found out. And there's a really interesting history behind it. Not going to do that. What I will say about creating a valid will is that North Carolina law allows for what we call a self-proving will. And that is your standard procedure where you go to the lawyer's office and the lawyer pulls in the person at the front desk, maybe another lawyer or a support staff, and witnesses you signing the will. And a notary is on hand. Sometimes it's a lawyer, sometimes it's someone else in the office that will witness the signatures, everybody signing, and put the stamp on there and certify it. That's called a self-proving will. It's not absolutely necessary that a notary witness it, but the clerk's going to have a harder time validating the signature because essentially he or she, the clerk, has to call in the witnesses that have appeared there on the will. And the witnesses are a requirement. The testator must sign in the presence of the witnesses, and the witnesses are attesting to their presence by signing also. But without a notary stamp, the clerk has a question. Well, I don't, about whether or not they can accept this without getting testimony from the witnesses, and the witnesses may be gone, moved away, dead. So always have a notary stamp, and always make sure that your notary actually stamps, because that sometimes can be an issue too. You can fill out the notarial block there, but you might forget to stamp, or the notary might, and that could be an issue. I wrote up a piece, and it's on the Farm Law site. If you'll go to the Farm Law site and type in the search holographic, I wrote up a piece back in the early pandemic about this because I was thinking about folks that have been thinking about estate planning for a while, about what they're going to do. And now that it's a pandemic and everyone's closed and the lawyers' offices are closed, even though lawyers were considered essential personnel, I was thinking about people at home and worried and fretting over this. And the article that I wrote said, it's okay. North Carolina General Statutes 31-3.4 allows for a handwritten will, the validity of a handwritten will. The two catches are that it must be written and signed in your handwriting. You can't type it up and then sign it at the bottom. That won't work. You write it out in longhand and sign it. Use the same ink color, I advise, and then put it in a file clearly marked "My Will," because another requirement is that it must be found not in the barn, but in in a file cabinet, or where, again, the term of art is where valuable papers would be kept. And I think something popped up. Oh, okay. I was seeing what was happening in the chat box. But holographic wills are admitted to probate all the time. And so I suggested, write one up. And here's some tips for writing it up. Here's the language to use and all that. But once this passes, get to a lawyer's office and, don't be in this situation again. But that article is on the site for your reading. I'm going to go past that. Probate, I don't really think we need to go through that, except the point that I want to make, that sometimes people have a misconception about, is that the executor, the person named by the testator as their executor, they're really suggesting who they want, because the clerk still must approve the executor. And if you name an executor that has, say, a felony on the record or something, or even a financial misdemeanor or something, the clerk may not confirm that person, because this is a fiduciary duty. It's someone that the clerk can't watch over their every movement. They just review the reports that are submitted, but they need to know that they can trust this person to carry out the distribution of this estate and get this estate closed. But what the power the executor does not have, which some folks get confused, is that, well, wait a minute, they named my sister, my sister's been named the executor. I don't trust her on how to divide up this property. the executor doesn't have that authority. The property has already been divided up by the will. And the executor has no authority to pick and choose which items are going to go to which person. If you make a statement in your will that I devise my property, that means your Chinaware, your farm equipment, your land, it's going to be divided up in shares according to whoever you've named as your legatees. And it's not as if the executor can say, well, I'm farming, so I'm just going to keep the tractor. The other siblings own that tractor also. Or I'm farming, I'm going to hold on to that good piece of land over there. And it doesn't work that way. All of the legatees, the people who've inherited, they own an interest in each of those items according to how it was divided up. And so the executor's role is merely to follow the rules of settling the estate and make sure that everything gets closed out. And a lot of times it's not a physical transfer of property. It's because it might be stocks or intangible assets. But the clerk is just telling the executor is telling the clerk of court, here's my form. This person got a third of everything. This person got a third of everything. This person got a third of everything. And there's a value attached to it. It's not as if this person got this equipment, this person got this land, this person got these stocks. The heirs have to do that themselves. Clerk doesn't want to hear about it. The executor has no authority whatsoever to make those decisions. Don't need to talk about that. Just talked about that. Don't need to talk about challenging a will, but just know that it is possible to challenge a will. If you think that one's been changed late in life, there are certain legal theories. Just know that you, as the would-be heir, or somebody that feels as if they've been cut out, you have to have standing. You have to, the court has to look at you as somebody that has an interest in this, and you have to bring it. You got to bring the claim. You can't just say, I think they lacked capacity, and then the judge decides or the jury decides, no, you have to bring the goods. You got to bring the evidence to prove these theories to the court's satisfaction, or to the jury's satisfaction rather. And it's a lot of elements, and I listed them here in it's small print, and we don't need to go through them, but just know that when if you do challenge a will, you got to bring the claim. Intestate succession, again, we don't really need to go with that. So finally, in my last few minutes here, trusts. I talked about trusts earlier as, as my go-to instrument in farm estate planning, because I want to have a mechanism by which two things really. I express how I want the property divided up, but because trusts tend to be longer than wills, and you can change them more easily, you can amend them, that I prefer that method, because you can go into a trust and zero in on a certain clause that you want to change, and change it. And then that'll change the trust. And so what you're doing in the trust, it's a document. You're telling the trustee, here's how to divide up my property. Here, give the equipment to this heir, give this piece of land to this beneficiary, this piece of land to this beneficiary. And I've been through this process with clients where, we go through, I'll ask them, which counties do you own property? And I'll go into the GIS and pull down all their property. And then we'll sit there and we'll look at it, and I'll describe the property in the trust and say, these tracts are going to this beneficiary, the named beneficiary, and I'll list the tracts and how they can be easily identified, so there's no mistake. But sometimes things will change in a family, and I might get a call from somebody I developed a trust 4 years ago, says, it was going to go to this person because that person's children were interested in farming the land. That's not going to happen. I want to go ahead and make a change and have that tract go to this other person. And that's one of the key benefits of a trust, is the utter flexibility that you have to make changes to it, but also to allow your trustee to make decisions based on, again, what they see as at the time that that property is passed into trust, and it's likely ready to be distributed. And so, but executors, they don't have that authority. That they're just making sure that the property is accounted for and divided up. But again, and I guess we're ending at 11. And again, I'm really sorry for getting hung up early, but there are a number of different types of trusts. The most common trust that I would use would be a revocable trust, meaning that we can develop the trust. You can deed property to the trust or not, yet, but you have a will that when you die, all of your property is going to be poured into the trust. Why do you have to do that? Because the trust is not a person for intestate succession. So, and this is an important point, you can have a trust, but if you don't have a will and you own property outside of that trust, you haven't put property in the trust and you die, your property is going to be distributed by intestate succession. It's not going to find its way to the trust because the trust is not a living human that exists for the purpose of being an heir. A trust is never an heir. It's simply a bucket that you can pour assets into, and then that bucket has instructions for the person holding it in terms of how they ladle out assets and distribute them. But I start with a revocable trust because, an irrevocable trust is irrevocable. Once you do that, it's very difficult to undo. But there are certain times later in life where you might want to switch to a revocable trust to take assets out of your name if you're doing some advanced pre-planning for maybe Medicaid qualification or whatnot. I always thought it's easier to toggle a revocable trust into an irrevocable trust with some simple language, an amendment, rather than the elderly client having to face the concept of just forming an irrevocable trust in that time. To me, the revocable trust is your training wheels. It gets you familiar with the concept of what the trust will do for you and your wishes and your assets. But there's lots of things you can do with a trust. Those options that I talked about, the options to purchase, all that, you can put those in there. What I would routinely do when I was listing out properties to go to specific beneficiaries, I would put a requirement in there that before the trustee distributed the deeds to those properties, that those beneficiaries, all of them, had to sign options to purchase or rights of first refusal, so that if one of the beneficiaries was going to sell their piece, the other beneficiary had the right to pay a certain amount to buy that piece. He maybe even have it financed by the person who owns it, so they don't have to go get a bank loan. Requirement of leasing the land to the farm operation, allowing even the trustee sometimes to form a limited liability company or execute a tenancy in common agreement that everybody is required to sign before the property is distributed. So very, very flexible instruments, and they work quite well. And you can put anything in a revocable trust. Your land, you can put business entity interests. That's all on paper, but you just draw out the paper and says, I'm transferring this interest into my trust. The big thing about trusts is that if property is inside the trust at the time you die, it's outside of the jurisdiction of the clerk of court. It's not a probate asset. It's not part of the probate process. The clerk has no ability to look inside that trust for property that's already in there. But whatever you don't have in trust and you die with, but before it's poured into the trust, it's going to be it'll be probate property. And how you fill out the probate form, if you have a pour over will that pours into a trust, and on the probate form it asks for the heirs or for the people who are going to inherit property. You just write the trust because that's the heir. The trust is the entity that's going to inherit, so to speak, that property. One challenge, though, as we wrap up here, trustee succession. Normally, people will name their children, one or more children, to be trustees. That's something to think through and have the buy-in of that person But sometimes folks want to leave trusts open for a long, long time. And I advise against it, because unless you have a lot of income being produced, by the trust, it's hard to keep assets in a trust without liquidity, because taxes have to be paid, insurance has to be paid, things like that, on the assets, on the land. And so my preference is always for distributing the property out of the trust after the settlor, the grantor who created the trust, dies, to go ahead and deal with that. But there might be situations, as I mentioned earlier, that require assets that have been set aside for a particular beneficiary to stay in the trust until those issues resolve themselves. But the law allows a trustee to decant a beneficiary's portion of the trust into its own trust, and then it can be used for that purpose, rather than mixed in with the other beneficiary's assets. So again, all I'm illustrating is very, very, very flexible. This is, I hope you can follow. This is just a quick diagram about, and there's some things I'm not explaining in here. The disclaimer: sometimes a spouse can disclaim an interest in property, and it effectively goes back to the will and then goes into the trust. And then the trust, that's where the language is. So the farm business entity, if there's an entity, it goes through the will, or the equipment, it goes through the will into the trust. And then the trust will determine how the property is going to be divided up and distributed. And I put over here inherited land, because trusts are often used in families where the land has come down on one side, and the spouse who has inherited the land is particular about ensuring that the spouses of children A, B, and C don't somehow get an interest in this land. And so the trust can use language to deal with that, that contingency. And an example being is that if a child is in a divorce, or if something like that's happening, then the trustee can make sure that that property does not become part of the divorce estate. A divorced spouse has zero interest in any rights of the other person. They're two strangers at that point. That's what I have. I didn't go in and talk about business entities in any great detail. That I'm finding is its own topic. So, but I work for y'all. Any questions that you ever have about things, or information that you need, things like that, feel free to send me an email. I prefer that. I can get my office email, but in the pandemic, I'm teaching online from Chapel Hill. I haven't been to my office in Nelson Hall in some weeks. So, but that's what I have. If anybody's got any questions, put them in the chat box or speak up, and let's talk.
Andrew, we do appreciate it. That was a wealth of information. I learned quite a bit myself. And like he said, if you have any questions, feel free to. We've got sort of a small crowd. Feel free to unmute yourself and ask, and we'll try to get them answered.
I would also say that I do appreciate questions from the field, because it always gives me article ideas or things that I know that I need to be addressing. I will say that usually after a real heavy rainstorm, I get a number of calls or inquiries about water trespass. That's a fascinating topic to me. It's one I'm not an expert on by any means, but I do research on it, from time to time, because I get questions about, drainage decisions that the developer next door has made are now suddenly inundating your property with sediment and water. So it's where I get ideas and how I keep in touch with what's needed out there from Cooperative Extension as a service to provide to y'all. So what I'm saying is, please contact me. I'm always appreciative of finding out what's on people's minds. Okay. So, oh yeah. So the recorded version, actually, Matt, that's you.
I've recorded it, and I'm going to I'm gonna create a little resource page for us here, and because this is a 4-part series. We have different speakers each week, and it's going to be each Thursday for the next. It'll be 3 more weeks after this, each Thursday at 10 o'clock. So feel free to join us. And Andrew, if you got some time and want to,
Yeah, I'm very interested in joining. And if Matt, if you have that link, if it's, I don't know if you record it on your computer or in the cloud, but if you send me the file or the link, I'd like to post it up on the Farm Law site also.
All right, we'll do. I think I did it to my computer.
Okay.